everyone, I'm Monica Hakimi. I'm a professor of law at the University of Michigan Law School, and I'm delighted to welcome you to the 5th session in ASIL's series, International Law and the 2020 Presidential Election, What's at Stake? Our topic today is on the use of force in counterterrorism policies under international law. Of course, any discussion of the use of force and international law begins with the UN Charter, and the Charter framework on the use of force is relatively straightforward. Article 2.4 prohibits states from using force, and I'm quoting here, against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. That language has long been understood to prohibit any use of force by one state in another without that latter state's consent. The Charter recognizes only 2 exceptions. First, states may use force through the UN Security Council. Second, they may use force outside the Council in individual or collective self-defense if an armed attack occurs. So this basic framework has never really worked as it was supposed to do, but its bare bones structure is still with us. I think it's fair to say that the key players in the international system have found ways to adapt but not kill it over time, as their geopolitical realities and security challenges have changed. And the central question that we'll discuss today is how the US security policy is likely to interact with the Charter framework under either a Biden or a second Trump administration. I'm really delighted to introduce our 2 panelists today. Tom Lee is the Leitner Family Professor of International Law at Fordham University School of Law. And Ona Hathaway is the Gerard C. and Bernice Latrobe Smith Professor of International Law and the Counselor to the Dean at Yale Law School, as well as a professor of the Yale University Department of Political Science. Each of our panelists today has served as special counsel to the General Counsel at the US Department of Defense, Ona during the Obama administration from 2014 to 2015, and Tom during the Trump administration from 2019 to 2020. So they're well positioned to inform us of how the 2 presidential candidates are likely to approach this body of law in the coming 4 years. So welcome to both of you. Thanks for being here. And maybe we could just start with a practice that dates back to the George W. Bush administration, and that is US counterterrorism operations that are conducted in other states without their consent. As the Obama administration left office in December 2016, it issued a comprehensive document that addressed, among other things, its legal positions on self-defense against non-state actors. And these positions continue to be very controversial, both in international and in domestic law. And so, Tom, maybe I could start with you, and I could just ask to what extent the Trump administration has adopted wholesale, as opposed to in some way modifying the positions that the Obama administration presented as it left office.
Great, thank you, Monica, and thanks for everyone for listening to our comments today. I think generally there is a provision in the National Defense Authorization Act, Section 1264, that requires every fiscal year the White House and the administration to report on various military forces and related national security operations. And I looked through the 2018 and 2019 reports, and they're pretty much entirely consistent with the last report of the Obama administration in 2016. So I think that with respect to counterterrorism operations, the reporting indicates that the Trump administration is pretty much following the same course that the Obama administration had done.
So Ona, do you agree with that characterization of the Trump administration's policies, I guess is my first question. And my second question would be, since Obama left office, I think it's fair to say that many on the political left seem to have become more skeptical of these positions. And so the second question would be whether a Biden administration is likely to change course or to continue these policies.
Yeah, so thanks so much for having me. It's great to be here with you and to have a chance to have this conversation. So I guess I will start by noting that it has long been a problem. So this is not just a Trump administration problem, but it's long been a problem that there's no mechanism to force administrations to really fully articulate their legal positions on these matters. So as you rightly said, Monica, the Obama administration put together this report sort of as it was walking out the door of what its sort of set of policies were that it claimed sort of it encapsulated the policy of the Obama administration that had been developed over the course of the 8 years of the Obama administration. And that was really the first time they kind of put it all together in one place. Now, we haven't seen anything from the Trump administration sort of explicitly either adopting that or rejecting it. the Obama administration had done a lot of speeches and various things to kind of put out its position, though it didn't have sort of formal legal, very many formal legal positions put out there. It did go out in public and articulate its views. And so part of the difficulty in answering your question is we just don't know with great certainty. We could do what Tom has done and sort of look at the reporting, the war powers reporting that's been done. But that wouldn't necessarily capture what's happening from the CIA side or special forces or working through partner operations. There's a lot of things we don't know, and we don't have a lot of information as to what their policies are. We have bits and pieces that give us some clues. And we'll talk about a bunch of these things over the course of time of this conversation. But just to take one, the Trump administration seems to have taken a more aggressive view of the scope of self-defense right of the United States. So you mentioned Article 51, right of self-defense. And I think you and I are in agreement that the Obama administration kind of pushed the envelope on that to some degree. And it seems that the Trump administration has pushed the envelope further. And one way in which it's done that is asserting a right of self-defense on behalf of non-state actor groups. So asserting that we can act in our own self-defense on behalf of the Syrian Defensive Forces in Syria, which is a non-state actor group that's not part of the United States. It's a bunch of people from Syria who are fighting the Assad government, but also fighting ISIS. So that's a step further than what the Obama administration had articulated. Now, they never have really put it into a formal legal opinion, so we don't precisely know what the justification is for that, or exactly how they would explain that as falling within Article 51, what authorities they might look to, because we don't have anything along those lines. But there's lots of indications that they've continued to kind of push the envelope and maybe pushed it to the point where it really is past breaking. And that's just one of them.
Great. So Tom, let's come to you, back to you then to ask about this wrinkle that Ona just mentioned. So I take it, so the question is, right, we invoked the right of collective self-defense to intervene in Syria on Iraq's behalf against ISIS. And then we claimed the right to defend our non-state actor partners against other states, particularly, I think, Iran, right? And maybe Russia too. And so could you talk a little bit more about what exactly we claimed and how this claim squares with US and international law, how it pushes the boundaries, as Ona said it does, and what limiting principles exist on it?
Right. So, Ona raises some good points. And I think one that she's right on is the Trump administration just has not done a very good job of, in speeches, publicly articulating its reasoning. That's not necessarily to say it's not happening, because the same lawyers are at the Pentagon and not necessarily National Security Council. You've got the same lawyers who are doing the analysis, but they haven't been as public in giving speeches. I will say, and I sent it to Ona and Monica, the General Counsel has given 3 speeches of the Defense Department on operations, the Soleimani strike. He delivered a speech in March at BYU, and on cyber operations, he delivered a speech at Cybercom in March. So the Defense Department has tried to articulate its reasoning, but I do think that as a general matter, there's been a lot less public reporting. The reporting that I mentioned earlier weren't the war powers reports. They were the Section 1264 reporting required under the National Defense Authorization Act. And it's really stunning, because if you look at them, you could take the year out and you couldn't tell which administration wrote it. I mean, it could just as easily be 2016 as 2018, 2019. And I hadn't done anything like that until I was getting ready for this panel. And I was really struck. I mean, they must have used the same template, it almost looks like, right? So the similarity on those issues is really striking. The Syria justification, I'll use that as an example. So we have allies who are non-state actors in Syria. And I'm actually quoting from the 2016 Obama administration report, which I'm looking at. I mean, the Trump administration is using precisely the same rationale. So the idea, I think, is that once we have a reason for using force in Syria under international law or domestic law, and let's call that international law collective self-defense or individual self-defense. I think there's an understanding that basically there's a unit self-defense logic that attaches, so that basically if you're there to combat ISIS or to combat some group that was associated with the 9/11 attacks, and you're being attacked by somebody else, it's logical that you should be able to use force against that other force. And that's not a logic that's new to the Trump administration. That's in the 2016 report as well by the Obama administration. So I think that it is something of a stretch. I mean, obviously it doesn't track the exact language of the charter as well as it should, because there's no mention of unit self-defense under these types of fact patterns. But it's definitely, so it's problematic in that respect, but it's not something new, because it's something that the Obama administration had been doing in 2016. And with respect to your question to Ona about, well, what are the predictions with regards to how the Biden administration is going to react? I really don't think much is going to change. And the last point that I'd like to make here is one thing that has been happening in the Obama administration, and this is not necessarily legal, but it's policy, is the Trump administration has been focusing a lot more on the idea of near-peer conflict rather than counterterror. And so to some extent, if you look at the publicly disclosed number of, for example, drone strikes, it's gone dramatically down in most of the countries. I mean, Libya, Yemen, Pakistan, Afghanistan, except for Somalia is the one exception. And so in some sense, part of what's going on here is the Trump administration, from a policy perspective, is trying to look away from the counterterrorism operation, certainly more than the Obama administration in the latter part.
Mm-hmm. Ona, do you want to weigh in?
Yeah, just a real quick response. So I agree that the idea of unit defense is not a new one, but the Obama administration never went all the way to embracing the idea that that non-state actor groups could be defended under somehow our umbrella of self-defense rights extending to groups that we're collaborating with, even if there are no US forces embedded with them. So I think the Obama administration would have said, we have forces embedded with the unit, then we can defend it. And there's room for argument with that. I might take some exception to that, but I think that's probably a more widely accepted view. The step that appears to be novel is the embrace of the idea that we can defend SDF forces, these non-state actor groups in Syria against attacks from other states, including their own state, Syria. They're not legally operating in Syria, and so Syria legally under international law has the right to go after armed non-state actor groups within their own territory, potentially bringing us into conflict as well with Turkey, a NATO ally, because NATO regards them as affiliated with terrorist groups within Turkey. And so actually one of the really scary moments was when Turkey was going into the northern part of Syria, going after SDF forces. And there was a question as to whether the United States was going to be coming into direct conflict with its own allies, with the NATO ally, which is Turkey, Russian forces, et cetera. So that's a step that we haven't seen. We did not see the Obama administration embrace, and that's a step further. And I think part of the problem too, just the broader issue, is that we almost never see, with the exceptions that you've pointed out, and I think those are important exceptions, but we see very little articulation of international legal basis for action by this administration. So they are more willing to articulate the domestic legal reasoning, but we very rarely see in any serious effort to really encounter and speak about the international legal basis for an operation. And when we do hear them talk about international law, and this is not so much in the use of force area, but when we hear them talk about international law generally, it's much more denigrating international law, denigrating international institutions, withdrawing from international law, talking about international law as a constraint on US sovereignty. So it doesn't give a whole lot of faith that there's seriousness of purpose being taken when they're making these really important decisions on use of force. And we have no evidence other than being able to talk to people like you that they're doing that. And that, I think, is one of the things that's really troubling. What will happen under the Biden administration? I can't say with any confidence. I don't speak for the Biden administration, so I can't say with certainty. I do think I interviewed Jake Sullivan yesterday for my own series of events on COVID and the global order, sort of how has COVID affected the global order. And we had a session on national security and asked him much that same question. He also said he couldn't speak for the Biden administration, though he is probably in a much better position to do so, given that he worked directly for Biden as his national security advisor when he was vice president. And he suggested that many people on the left, and I think you said something along those lines, many people on the left recognize that we need a change of course in the counterterrorism area, and that the direction that we've been going, that the Obama administration went, and that the Trump administration has sort of extended and expanded, is probably the wrong direction for national security. And we need to be thinking much more about other ways of using our power and authority to influence the world, as opposed to simply dropping bombs, which seems to have been one of the key ways in which we've decided to influence abroad, and not a particularly effective one, it turns out.
Good. Tom, go ahead.
No, so I think Ona's right that the Trump administration, and obviously I'm speaking in a private capacity. I mean, both special counsel positions are non-political positions, and nothing I say is official in any sense, but it's personal capacity. But clearly, the Trump administration has been much more resistant to supporting international law and institutions, and in the analysis that's published, with the exception of the general counsel's speeches that I mentioned. I mean, international law sort of doesn't really get mentioned at all. I mean, they did file an Article 51 letter for the Soleimani strike, and so the administration has sort of done the absolute minimum from a formal perspective, but not much more. And I think that that's somewhat unfortunate, because to some extent, it puts the United States in the position of making these types of arguments on its own rather than with allies and so forth. And I think the Obama administration was much more successful in developing coalitions for its positions. But query, based on what Ona just said, whether that's a good or a bad thing, because if you've got everyone sort of going into this very aggressive counterterrorism direction, I mean, maybe from a sort of legal architecture perspective, that's actually not good, right? I mean, the Obama administration waged a largely successful campaign for unable or unwilling to become sort of a part of the customary jus ad bellum firmament, and now it's there, whether you see it as a gloss on self-defense or whatever. And so if that had happened with the Trump administration, I mean, I think we'd be in a very different place in terms of international law architecture. So I think that's a point worth making. On the specific point, I mean, and this might get too much in the weeds, but it's a very important point, the extent to which the Trump administration, at least as a matter of public record, has been engaging in support of various non-state groups in Syria that are actually fighting, the Assad regime and so forth, where there might even not be embedded U.S. soldiers. I mean, I think operationally, it may be at least what was reported in terms of what was reported in the public record, something new. But in terms of legal authority, I'm reading a sentence from the Obama administration's December 2016 report. It says, the United States is using force in Syria against al-Qaeda in Syria in self-defense of the United States. And then in furtherance of the security of US partners and allies, it doesn't say state partners and allies. And so I think that basically that was deliberately ambiguous. And so I think in terms of legal authority, if you read the documents that they've set forth as the legal framework, it certainly seems capacious enough to support partners, including non-state partners that are engaged in combat operations in Syria. So operationally, at least from what we know from the public record, I think you're right. I mean, the Trump administration may have gone one step further, but certainly in terms of legal authority, what the Obama administration had articulated seems roomy enough to cover what's going on.
Just super quickly on that very last point. Sorry, just want to jump in really quick. So as I understand it, that the articulation of that view is in that report is really just about justifying use of force against ISIL, the colloquially
doesn't really
known
say
as
that,
ISIS,
though, Ona,
as opposed
right?
to U.S. operations against ISIS in Iraq are thus conducted in the context of armed conflict and in furtherance of Iraq and others' armed operations. Is that, so that's, I mean, so the question is, at least my very clear recollection from working on these issues was that that was not a position that would have been articulated. But I think we're in agreement on the basic point, which is that there is a kind of interesting refusal to even articulate an international law justification by the Trump administration. And you raise this intriguing idea that not articulating the reasoning is a good thing. I guess the worry I have is that just opens the door to lawlessness. That while I agree that pushing the envelope and getting lots of other states on board with pushing the envelope is probably harmful as well, it's more harmful to be engaging in action without providing any legal justification. Because if you do so, then what's to ensure that you're staying within the legal boundaries? There's very little, and that's the worry.
And I think that's a legitimate worry. I mean, I think that well, point one is obviously the legal analysis is still going on in the relevant actors, but they're not showing their work, right? And so I think that the implicit point in what you say is that combination opens up the potential for some degree of lawlessness, and I think that's a fair consideration.
Well, so maybe I want to, if it's okay, I'd like to crystallize just like 2 points that I think you two are circling around or addressing. And I think actually we can use the Soleimani incident from the very beginning of this year to crystallize both of them. So the facts, I know that you two know this, but just for our viewers at home, are pretty straightforward. In the early days of January of this year, the Trump administration struck Iranian General Qasem Soleimani while he was traveling in Iraq. And by most reports, Soleimani was involved in various acts of low-level violence against the United States and its allies in the region. But it was clear at the time, I think, to people who were paying attention, that the U.S. response, the U.S. attack on him, upped the ante and was particularly brazen. And so and in the immediate aftermath of the strike, the justifications that were on offer in the public discourse, at least, seemed to me, and Tom, you can correct me if you think this is not right, or Ona, you can correct me, although I think you might be less likely to correct me, seemed to me to be sort of all over the map. Like there were various justifications, they seemed to be shifting and untethered, not substantiated in fact. At times, the administration, including the president and the vice president, seemed to be trafficking in lies and conspiracy theories. And then, as you say, at some point, the administration filed an Article 51 letter with the Security Council. And so the first question justifying the operation in self-defense, or saying that the operation was justifiable in self-defense. And so the first question is, I guess, just as a matter of rhetoric and discursive engagement with the law, whether that kind of engagement is itself a problem, and if so, why exactly is it a problem? And I think that relates to the second question, which is was the U.S. action really outside the bounds of previous decisions? And here, I guess I want to crystallize, I think, a point of tension. Tom, I hear you to be answering this question at a level of higher generality than Ona is. So I think you want to revert back to some like articulations of general standards that were presented by the Obama administration. And I think Ona wants to say, but as applied, it was as applied in a more aggressive way than it was ever applied before then. So I guess I want to ask you how much of your dispute is about the level of analysis whether you're looking at the general standards or the actual application of those standards to concrete incidents. And so those are two big questions. There's a lot to say in response to them, but maybe we could use the facts of the Soleimani case to sort of unpack those questions a little bit. And Ona, maybe we'll start with you on this one. I don't remember who started the last round.
Sure. So I think what was really striking about the Soleimani strike was this is a very provocative move, as you rightly said. You know, you're striking high-level Iranian military leader in the territory of an ally, with very little warning to apparently any allies in the region, allies in Europe, no advance notice as far as we know to Congress. So there's something very striking about the way in which the strike was carried out. Like none of the ordinary notice. Then when it comes to the legal standard, I think you rightly said, they were kind of all over the map. They were claiming initially that this was, or they seem to have tried to claim that this was necessary because there was some kind of an imminent threat. But then they really failed to substantiate that. So they claim self-defense, but in order for it to be self-defense, there has to be some kind of a threat that you're defending yourself against. So you have to be able to say, this is not just that we don't like this guy, and we think he's a bad guy and we want to kill him. You've got to actually, if you're going to act under self-defense, you've got to be able to say, here's how this action is actually going to make us safer. And here's what the imminent threat is that we will be putting to an end by taking a strike. And of course, none of us are privy, or at least I'm not privy to the classified intelligence on this, but the people who were privy to the classified intelligence on this are members of Congress who were briefed, and members of Congress who were briefed after the strike. They were upset about that, and rightly so, because we're primarily focusing on international law, but under domestic law, ordinarily, that's the sort of thing that they would have at the very least been informed of beforehand. But they came out of those briefings saying that, as far as they could tell, there was no basis for the claim that there was an imminent threat. Even Mike Lee, Republican of Utah, who's been in the news lately and not very favorably, so that he was unsatisfied with the information that was being given for the legal, factual, and moral justification for the attack. And he found it, quote, insulting and demeaning. And a number of members of Congress came out. My own Senator, Chris Murphy, came out of his briefing, and he tweeted that the bottom line is this: I did not hear evidence of a specific imminent threat that would allow an attack without congressional authorization. And he said, with the consequences as serious as these, this is unacceptable. So they mouthed the words, self-defense, Article 51, imminent, but then they didn't actually substantiate it. And even to this day, there has not been any evidence provided that suggests that they actually had the facts that they needed to legally carry out that strike. And the consequences of the strike were that Iran then retaliated against our forces in Iraq, and 109 troops suffered traumatic brain injuries in these retaliatory strikes. And so it wasn't without consequence. It had consequence, and it could have been a lot worse. I mean, it could have ignited a war with Iran, which would have been truly devastating and brought us into yet another massive Mideast war with a country with a much bigger military than the others that we're at war with now. So it was a very dangerous move to take on very little, very thin, if not non-existent legal basis. So I think that illustrates exactly the problem. They know what words to say, but then they can't back it up.
Mm-hmm. Tom?
So, I'm not going to disagree with the fact that it was handled poorly in terms of process, both in terms of the mixed messages that were being sent out publicly, and also the failure to give sort of more of a heads up to the relevant members of Congress. And I think that was highly unfortunate. In terms of the legal analysis, and really those are more sort of policy decisions, right? In terms of the legal analysis, I think that, but they're connected because the rhetoric about, well, there was an imminent strike that was going on, sort of conditioned congressional members to say, okay, well, if that's your reasoning, show us the evidence. And in fact, at least what was disclosed as a matter of public record, and people who were the members of Congress were unsatisfied with the intelligence that was provided for those bases. But the legal standard itself has never been, you have to know that there's going to be a strike tomorrow, right? And again, I'm going to read from the Obama administration's 2016 report of the legal standards. So the legal standard says, this is from the 2016 framework report from the Obama administration, open quotation, the absence of specific evidence of where an attack will take place or the precise nature of an attack does not preclude a conclusion that an armed attack is imminent for purposes of the exercise of the right of self-defense, provided that there is reasonable objective basis for concluding that an armed attack is imminent. Finally, as is now increasingly recognized by the international community, the traditional conception of what constitutes an imminent attack must be understood in light of the modern day capabilities, techniques, and technological innovations of terrorist organizations. Now, so I read that to say you don't have to be able to point to a specific attack. And if it's a terrorist group, there are special other factors in play, and that's sort of the legal standard. And Jay Johnson, as you probably know, came out and said, I think that on what I've seen, that it was an entirely legal attack. I mean, Jay Johnson, who was the general counsel of the Defense Department, Secretary of Homeland Security, and Soleimani was not just any Iranian major general. He was in charge of the Iranian Islamic Revolutionary Guard Corps, which was sort of this transnational paramilitary organization that sponsored terrorism across the board, and in fact had been designated a terrorist organization by the State Department in April of 2019. And Secretary of State Pompeo said, well, this is not, next to Osama bin Laden, he's the #1 sort of terrorist leader out there. And to some extent, the fact that he wore an Iranian uniform doesn't necessarily cloak the fact that he was sort of in charge of an organization that was interested in fomenting terrorism across the board. And so I think that, and in fact, not just Jay Johnson, but a number of senior Democratic leaders said, yes, he was someone who was the head of a terrorist organization. And probably the characterization of him as sort of a second Osama bin Laden was correct, right? So that's the counter argument for the legality piece. And this is something that we can debate at greater length, but it was a targeted, and in terms of proportionality, I mean, it was targeted, he was in Iraq at the time, meeting with an Iraqi-based militia that had just sent multiple rocket attacks on US bases in Iraq. And the leader of the Shiite militia in Iraq was killed with him. So in some sense, Monica, I'm sort of going, I can't obviously talk super specifically, but I'm going to go specific enough here. On these facts, it's a very compelling case for attacking him. And I highly recommend to the listeners the speech that Mr. Nye, the General Counsel of the Defense Department, delivered at BYU in March, where he articulates all of these facts. And you'll see from the speech, it's highly fact intensive. And when you're dealing with, this kind of law is much more like common law, case-driven type methods. They're all driven by the specific facts. And I think that in this particular instance, if you look at the facts, there's a very strong case for legality. That doesn't mean it wasn't handled poorly in terms of process, both domestically and internationally. But if you look at these facts and the legal standard, I think there's a pretty strong case for coming to the conclusion that strike was valid.
So good. So let's talk, this panel is mostly about international law, but let's talk for a minute about the US legal authority for using force against other states outside the United States. And I want to talk about this for a minute because I think there was an impression, and Ona said at the time, that maybe we were heading toward all-out war with Iran, and we were doing so without any specific congressional authorization to that effect. So the president was essentially making a decision, or the executive branch, you could say, to the extent those are different things, was making a decision on its own to use force against Iran and in Iraq. So without specific congressional authorization for that action, with the risk of then having a full-out war, at least among the view of many. How is that possible under US law? And is it something that is likely to persist under a second Trump administration or an Obama administration? Or is there some way to, let's say, impose limits on what many people perceive to be too long a leash on the executive branch ability to take us into war?
Yeah, I can take a quick stab at that. So just really quickly on the last point, and then before I turn to the war powers stuff, I just think the difficulty here, yet again, is that the administration really is asking us to take all that information on faith, and that's the difficulty. And if you look at the Article 51 letter that they submitted, they didn't talk about any of those facts. They talked about some old attacks on USS Boxer in July 2019, 6 months earlier. So that doesn't give a whole lot of confidence that the basis was that there was actually sort of imminent attacks coming. They didn't even use the word imminence in their Article 51 letter. So there is, it's difficult to square what they said and what those who are privy to the intelligence came out of their briefing saying with the idea that this was consistent with the requirements of Article 51. But on the war powers side, I mean, I think what we've seen, and this has been a long erosion of war powers over the course of the last several decades. So this is not just a Trump administration problem. I think we can just as easily lay the blame on the Obama administration for doing harm to the capacity of Congress to put any limits on the president's use of military force. The obvious case here is the decision to use force in Libya without going back to Congress to seek authority, either in advance or seeking authority to continue operations past the 60-day mark, and claiming that use of military force in Libya wasn't hostilities and therefore not subject to the War Powers Resolution, which requires that Congress be notified and that Congress have an opportunity to make a decision about whether to continue operations past 60 days if the operation constitutes what's hostilities, which isn't actually defined in the War Powers Resolution. So I do think that the Trump administration, blew through that in the Soleimani strike, but it was kind of blown through to begin with. And my hope is that a Biden administration would be interested in thinking about comprehensive war powers reform. And I think comprehensive war powers reform is going to require rethinking what the relationship is between the executive and Congress over use of military force. I think Congress has been complicit in its own gutting of authority over time. During the Obama administration, the president sought authority for operations against ISIS. Now he, I think, made the mistake of saying he had all the authority he needed under the existing 2001 authorization, which I think is extremely debatable. And then Congress was like, of course, we're not going to vote a new ISIS AUMF because we don't want to own responsibility for that. And they let the president continue to engage in operations against ISIS based on a pretty tenuous legal argument that it fell within the scope of the 2001 authorization for use of military force, which was passed September 18, 2001, a week after the 9/11 attacks. And really, if you read it, you'll see that it is clearly intended to address those who carried out the attacks on us on 9/11 and not some future group that didn't exist at the time that might possibly be carrying attacks in Syria nearly 20 years later. So this is not just a Trump administration problem, to be clear. Mm-hmm. And why didn't they solve it under the Obama administration? I mean, there are a lot of reasons. It was not a priority. I don't think for very many presidents, limiting their own authority is a priority. And the Obama administration prioritized, understandably, healthcare reform and then lost control of Congress. And that kind of reform is just going to be extremely difficult without unification of the president and Congress. And, again, like, we didn't want to really spend his political capital on it. Will a Biden administration be willing to spend political capital on it? I don't know. I do hear from people a sense that the system is really deeply broken. And we've seen how incredibly broken it is and that it's just not sustainable, and a kind of sense of exasperation with it that is a step beyond what I've heard before. And so I do think there's more of an appetite for serious war powers reform and actually finding a way for Congress to be effective and actually being a partner with the executive in making decisions about when to use military force, which is its constitutional role. It is Congress, after all, that is supposed to be the one that declares war. It's Congress that has the power to raise and support armies. It's Congress that has the power to appropriate funds for our military, and yet it has played very little role in making any serious decisions. So I think that system's clearly broken. I think it's going to take a new law to do something about it. And really the only question is whether that's going to be high enough on the priority list that they'll get to it. But I really hope so.
Mm-hmm. Tom?
I'm happy to agree with Ona. I mean, the domestic side of the equation, the legal framework clearly isn't doing what it's supposed to be doing, which is having some effective role for Congress to have meaningful input. I mean, not necessarily a veto, but to some extent have the president in a position where there is a much more of a felt constitutional legal need to bring Congress into the equation before doing something extremely serious. And I also agree with Ona that their Rand strike didn't end up that way. And we, again, I commend Mr. Nye's speech for talking about it all, but in the larger scheme of things, it was sort of an aggressive move, and Congress should have been brought more into the fold, I think. And I also agree that we need to try to figure out how to reform the war powers resolution process. But I think that when I teach the war powers resolution, I sort of spend some time asking people, well, how would you design this mechanism? I mean, it's basically consult, notice, and then Section 205, which is the hammer, 60 days, or you have to pull them out, which is why the Obama administration was put into this absurd position of arguing that continuing to bomb because it was part of NATO was not hostilities, right? And so it's poorly designed to do what it needs to do. And so I'm kind of, from a design perspective, in a world where a lot of these threats are fast moving, in a world where congressional dysfunction is a very real thing, I'm hard pressed to figure out how to fix it, right? And how to sort of replace that Section 205 hammer, which doesn't really work very well. And I think it's even more of an imperative, because one of the things that I had mentioned was that it was very much a part of the Trump administration's sort of policy outlook. We want to move away from counterterror to near peer. We've got to think about China and the next war, because it's not going to be against ISIS or whatever. And if that's actually true, then the idea that we don't have more meaningful input from Congress just becomes that much scarier. And so I do think that there's reform. I'm just sort of at a loss to figure out how to fix it in a way that makes sense.
Mm-hmm. Okay, well, let's shift a little bit and talk about the Trump administration's Israel policy. So the current administration has shifted the longstanding U.S. policy on Israel's occupied territories. It has moved the U.S. embassy to Israel from Tel Aviv to Jerusalem, despite questions about the final status of Jerusalem, and particularly East Jerusalem. It has recognized Israel's sovereignty over the Golan Heights, which Israel seized after the 1967 or during the 1967 war. And it seems to have more recently been encouraging Israel's annexation of some or all of the West Bank. And in international legal circles, at least, some are saying that these moves hit at the very core of Article 2.4 because they condone or even endorse the acquisition of contested territory by force. And so, Tom, since I gave Ona the first crack at the apple last time, I don't know if that's the metaphor, but let's just use it as one. I'll start with you now to just ask you the question whether that's the right way to think about the Trump administration's shift in policy toward Israel as essentially condoning forcible annexations of territory in violation of the very core of Article 2.4.
No, and so putting my sort of international lawyer hat on, I think that's a fair concern, right? I mean, the rule should be that territory acquired by force of arms requires some level of consent before you can claim title, so to speak, right? And certainly that isn't what happened here. I mean, I think, and part of this is, I guess, sort of frustration, because I feel like the Trump administration had international legal arguments available to make because of the special status of Jordan and the fact that there's a peace treaty of Jordan, and Jordan was actually sort of, if you were to follow the property analogy, they were the ones who had title to East Jerusalem, and maybe they've ceded it. I mean, you could have made clever international legal arguments and try to socialize the position, but that's not what happened, right? And so, in some sense, I think that there it is this idea that have you caved into or made some kind of inroad that's potentially dangerous to a bedrock norm of the UN Charter World Order is a legitimate criticism. I will say that had the arguments been made, there are these special circumstances involving that particular territory that would, for example, allow lawyers to distinguish, say, Crimea and Russia or something like that. But the administration hasn't really engaged in that. I think the larger question is that the Trump administration, and again, this is policy, is sort of engaged in a very ambitious re-scramble Israel strategy here. I think everyone in the know knew that there were these sort of informal alliances with Israel and some of the other countries in the region, and now we're sort of surfacing them and solidifying them and putting together this other framework. And this is sort of a part of it, so that it's sort of like an Oedipus. Okay, I'm not supposed to use jargon, but it's sort of like completing a change that will allow the new reality to stick. And in some sense, it's difficult to assess whether that's going to work. My gut reaction is, because of the politics involved, this is one where the Biden administration may not go backwards, and they might actually continue carrying the football in this direction.
Well, so that sounds like the question for you. Do you think that the Biden administration would retreat to the pre-Trump status quo?
So I don't know for sure what they would do, but I certainly hope that they will. I think that this move that they've made to effectively endorse conquest of contested territory is extraordinarily dangerous. It may seem like it's sui generis, but this is, as you put it, really the core norm of the post-war era. The prohibition on territorial conquest is fundamental to the modern international legal order. It was not always this way. It used to be the case that when states had a disagreement with one another, they could go to war and they could take land. This is why we have much of Southwest United States, as we took it from Mexico because they failed to pay back a set of monetary debts to us. World War I scrambled the borders of Europe because that was permitted. Conquest by the victors was allowed. And one of the fundamental shifts that we made in, I argue in my book with Scott Shapiro, The Internationalists in 1928, but then reaffirmed in the UN Charter in 1945, was a prohibition on aggressive war, which is in Article 2.4, which is a way of enforcing this norm of prohibition on territorial conquest. And what these moves do is they really erode that. They suggest that it's okay to take land using military force. And yes, it's contested territory. We actually talk a little bit about it in the book and kind of how we got to this messy, awful place that we're in Israel. And the UN is actually partially to blame for that, because the UN mandate expired without a successor sovereign to take over the mandate. And so, there are legal reasons why we're in this mess, but endorsing the idea that you can solve it with force is a very dangerous precedent to set. And I think dangerous for the international order overall. And I think that a Biden administration is likely to recognize that danger. Obviously, this is very political. There's, lots of sensitivities involved in it. But I think there will be a lot of pressure to unroll some of that, because the dangers that it poses to the international system, I think, are ones they're going to recognize. And if you couple that with sort of the softening of the Trump administration on Russia's conquest of Crimea, which is the first successful conquest in Europe in the post-war period, it really does make you worry that we're seeing this kind of gradual erosion in kind of bits and pieces, but that bits and pieces could become a flood if we're not careful. And then we're really in a mess, because that then unleashes a very brutal and bloody period, I'm afraid.
Tom.
Just a very short rebuttal. I mean, I actually tend to agree with Ona about the importance of this norm, and I would sort of put as perhaps another indicator of what's going on in Kashmir. I mean, it seems to me that all of a sudden people with aggrieved territorial claims are being heartened, so to speak, which is disheartening. But I guess the counter argument would be there are sui generis one-offs, Crimea possibly being another one, and essentially it's possible to stop the erosion with these sort of incremental, one-offs, right? I mean, as I said, I'm skeptical of that view, and I think that I don't know if the Trump administration, the people who made the decision, considered it. I mean, it might not have been on their radar screen if it was a considered decision, saying like, look, we care about the norm, but we think that this is something that we could stop. Rather than something that's going to snowball and get away with this, but it is a very dangerous road to be going down. And I think the other part of the danger is you've sort of taken away any incentive of Israel or Russia to sort of try to bargain with the parties, with Ukraine, because now you've sort of you've changed the baseline. And so that's problematic, because once you recognize exceptions, the idea that everyone has to come and you've got to come to a deal is no longer as important as it used to seem, right? So I do pro bono landlord-tenant litigation, and it's absolutely clear to me that the only way to settle these things is actually settlement negotiations between the landlord and tenant. If you get a victory in a court one way or the other, it's really never going to end the thing, right? And so it's really unsettling that dynamic has been changed. So I'm kind of on board with Ona's take on that.
I will just say, for what it's worth, I am also very troubled by this trend. Okay, let's change course yet again and talk a bit about cyber warfare and interference, which is even more on the radar screen now than it was maybe 3 years ago or 4 years ago when the Trump administration took office. And my understanding is, but please correct me if I'm wrong, that as cyber tools have become more sophisticated and more common, states have tried to articulate whether and how international law governs their use, but there still is a lot of ambiguity on how international law applies in this domain. And so I guess the question is, to what extent are current US positions consistent across time? To what extent are they likely to remain consistent across time? To what extent are they consistent with the positions that other states are taking? And how should we understand this domain to be likely to develop in the next, let's say, 4 years? And Ona, I'll start with you on this one.
Sure. So I think this is just a fascinating area. And the short answer is it's very fast moving. There have been efforts to congeal the international norms on cyber, to get states to basically articulate what their perspectives are. There were sort of two, before the pandemic hit, there were sort of two ongoing efforts going on at the UN, sort of two parallel efforts going on to try and settle, make some additional statements about what the shared norms are. It wasn't clear that those were going to actually succeed. I think one of the challenges you face in this field is that the very states that normally would be on the front lines of trying to articulate rules, so the United States, the United Kingdom in particular, actually are pretty sophisticated actors in this space, and I suspect not so sure, they're not too unhappy about the ambiguity for now about what the legal rules are, because it gives a lot more room to move. And I think there's also worry that if we articulate clear legal norms in this space, that the law-abiding states, traditionally, again, the United States is one of those, is going to have to play by those rules, and our adversaries, Russia, Iran, North Korea, won't. And so that we'll sort of be tying our hands behind our back without any way of verifying whether other states are abiding by it. So I think that's at least part of the reason that despite the fact that everybody recognizes we need much clearer rules, there hasn't been a lot of movement. There hasn't been a lot of movement about what those rules actually are. They did get to the agreement that international law applies in cyberspace. So that was considered a big win. And that sovereignty applies in cyberspace, whatever exactly that means. And that the traditional rules of the UN Charter and IHL, international humanitarian law, the laws that govern the practice of use of force, govern in cyber. But really beyond that, sort of how they apply, much less clarity. What I would say in terms of a distinction between the U.S. position and the U.S. position under Trump versus Obama, I do think the Trump administration has been more, shall we say, forward-leaning. Others would say more aggressive. This so-called defend forward idea that this administration has embraced. It's sort of defined as confronting threats before they reach US networks. So instead of just waiting for threats to come, we're going to go in and advance. I don't love that phrasing because I think that going back to our earlier part of our conversation, it seems to suggest that self-defense is this kind of ever malleable tool and we can turn it into an offensive weapon. But when you dig into what they're actually doing, I find it much less troubling. What as best I can tell, and again, I'm not kind of read into the classified programs, but when you see descriptions of what's happening, it's working with allies to figure out what malware is operating in their networks and helping them deactivate it and detecting threats in advance. It's deactivating malware on systems, not just in the United States, but abroad. It's this idea of persistent engagement, that we're going to be looking for malware and threats around the world and identifying them and publicizing them. We have 68 cyber protection teams that apparently are out hunting for malware on our networks rather than waiting for attacks to happen. None of that, at least as described, troubles me. I am more troubled by the possibility, but I don't know that this is what's happening, that there could be more aggressive moves than that. I do think that, it's one thing to be hunting for malware. It's another thing to be putting malware in place. And there have been various stories out there that we have, set up a bunch of cyber systems to be able to take down the Russian electrical grid. I don't know if that's true. But if it is true, that does worry me. And that does create worries about how one could do that consistent with the law of armed conflict. But the vast majority of what I've seen, and there was a very interesting piece by Cyber Commander Paul Nagasoni and someone who's working with him, Michael Suhlmeyer, sort of articulating the policies recently in, I think it was Foreign Policy. And, what they laid out there really struck me as good. They were like basically doing right things. And they ended it by saying, our actions must also remain consistent with the law of armed conflict and other important international norms. So they specifically recognize the importance of that. If that's what's going on, I'm not so worried. As usual, I'm a little bit concerned about what we don't know. But overall, while they're taking a more aggressive stance, they do seem to be more proactive than the Obama administration was prepared to be. If it's actually within those guidelines and they're being mindful of the international legal norms, I'm not as troubled by it.
Great. Tom?
No, so, this was a large part of what I was involved in because a lot of the technology here is exponentially changing. And in my prior life, I'd been a signals intelligence officer, a cryptologist. And so it's sort of near and dear to my heart. But I think that a couple of things. One, Ona had brought up the example of bringing down a separate power grid. Whatever offensive cyber military operations are out there, I mean, two of the international law rules that the U.S. military abides by are anything that would amount to a use of force is off the table. And I think taking down a power grid would be off the table. And anything that would sort of And I think probably all three of us hate the word sovereignty because, and at DoD, I was constantly saying, what do you mean by that? Don't use that word, right? But so I prefer to call it a non-intervention norm. I think that we don't know exactly how far it stretches, but electoral systems, financial systems, like basic, infrastructure is part of that. And I think that the military sort of understands that those are sort of, that those are hard and fast rules. One institutional piece that's very interesting was for a long time, and I think during the Obama administration, there was sort of a institutional tug of war between the CIA and the Pentagon about who owned offensive cyber operations, because it was unclear the statute. So this is more US domestic law, but I think it's relevant to the international law analysis, right? So for the CIA, there's something called the covert action statute. And if cyber sort of looks like covert action, because the fact that the United States is doing it is not just attributed, and you're seeking to influence political, economic, and other systems. And so the CIA had sort of used that statutory framework to claim prime ownership over it. And in the 2019 National Defense and Authorization Act, Congress pretty clearly said, no, it's a traditional military activity. And so Cybercom, which is a military command, became the institutional actor that was sort of the primary force in this space. And so once the military gets involved, they have JAGs, and they have a much more sort of practiced, institutionalized legal architecture than the CIA does. I'm not trying to cut down on the CIA for covert operations, but the whole point of covert operations was to avoid scrutiny, whereas the military, to some extent, takes these rules much more seriously. And so by contrast to what's happening otherwise, I mean, it almost feels like because of the congressional interest and because the military is not used to acting covertly in this way, I mean, I think it's kind of a success story. I mean, the operations are proceeding, and I think as ONA characterizes, as a matter of public record, most of it is fairly harmless, preemptive kind of action. And it's very heavily lawyered as opposed to some other types of things, right? So it'll be interesting to see. I mean, and even as a matter of public record, the Trump administration has not been super aggressive about things that might be arguable uses of force in the cyberspace. So it'll be interesting to see what happens going forward, whether that's continued. I think that just from sort of informal discussions, my sense is the Biden administration will continue in that direction. This is another one, perhaps like the Israel issue, where once the genie's out of the bottle, it's very hard to put it back in. And the last point I'll make here is, unlike sort of kinetic conventional military, even though the United States is a leader in this field, it's much more of a multipolar environment. The Chinese, the Russians, the Iranians, the North Koreans, I mean, there's a lot of the Israelis, there are a lot of countries that are very, very good. So it's more of a concert of Europe type situation than a Cold War kind of situation. The United States does not have the luxury of sort of sitting back. And although I think ambiguity generally works to the United States' advantage, because it is still a leader. I mean, the Russians are always pushing for a treaty or something because, they'll adopt the treaty and it's just paper. I remember visiting Vietnam, and I like to, wherever I go, I like to purchase a copy of the local constitution. And so I asked my Vietnamese lawyer minders where I could buy an English translation of the Vietnamese constitution. And they gave me this 80-page book. And I said, wow, this is a really big constitution. And the guy, and this is sort of a Vietnamese, state officials, he's like, fiction. So anyways, so I think that it's not just that ambiguity favors the strong. There's definitely a sense that the United States also is dealing from a position of weakness, because if we were to sign on to hardwired norms, we would actually try much harder than some of the other powers to adhere to them. And so there's this sort of London Naval Conference kind of distrust of hardwiring a solution in. So it's a complicated space. It's an exciting space because the technology is really evolving at light speed. And so it's something that's interesting to observe.
Well, great. Maybe I'm looking at the time and I'm sort of hearing the ASIL people whispering in my ears that we've been going on for about an hour. So maybe we should stop at that point of relative success and agreement. And so I will just speak on behalf of myself, and I know the viewers and the society that this has been really very enlightening. Thank you to both of you for doing this. And I really appreciate your time. So on behalf of
Thank
everyone,
you so
Thank you.
much.
You did a
Thank you
fantastic job,
for this.
Monica. Thank you.
Yeah, thank you for organizing us.